Ripple has been the subject of a request for a definitive verdict from the Supreme Court of Canada. Today, the Securities and Exchange Commission puts forth a civil penalty proposal with an aggregate value of $876 million. The imposition of this punishment will be obligatory as a condition for meeting the requirements. A strong likelihood exists that Ripple and other organizations will be dissuaded from committing similar violations in the future in light of this. How does the motion proceed with the inquiry? Ripple has a history of $1 billion in violations of securities regulations. Additionally, this action draws attention to the past. The occurrence of these infractions rendered Ripple predominantly liable for them, as the company offered and sold XRP to institutional buyers and other counterparties without first registering the transaction. Not only are the recovery of funds and the imposition of severe penalties mandatory, but they are also essential for deterring future illicit activity and ensuring that such conduct ceases. Furthermore, the Securities and Exchange Commission (SEC) highlights Ripple's lack of accountability regarding its violations, Ripple's denial of transparency regarding its business operations, and its depiction of the court ruling as a decisive triumph exemplify this denial. Ripple's decision to disregard legal counsel concerning the promotion of XRP as an investment and its cash sale in light of the counsel received implies a conscious effort to evade legal consequences. These two actions serve as indications that Ripple is unwilling to acknowledge accountability for the wrongdoings it has perpetrated. The Securities and Exchange Commission (SEC) asserts that penalties in the repayment of illicitly obtained profits are the sole means by which Ripple can be compelled to alter its conduct and adhere to the regulations imposed by security. In addition to addressing the market, the requested relief seeks to prevent additional violations that may deprive Ripple of illicit benefits. A legal expert by the name of Fred Rispoli explains the current dispute and legal conflict between Surge Labs and the Securities and Exchange Commission of the United States. Furthermore, his research provides valuable insights into possible substantial developments that could occur in the scenario. A motion recently filed by the Securities and Exchange Commission of Canada proposes that Ripple be subject to a penalty of around $2 billion. This motion provides insight into the consequences that this could have for Surge and the cryptocurrency industry as a whole. Her speculation strongly implies that the Securities and Exchange Commission's action will significantly impact both the Ripple market and the cryptocurrency industry overall. This is despite the fact that we foresee obtaining additional information from new papers. According to Rispoli, there are two potential outcomes, either a swift and peaceful resolution following the decision of the court or a drawn-out legal battle with restraining orders. Rispoli provides an analysis of the situation and its prospective consequences. Fred Rispoli, a well-known advocate of XRP, contends that the intricacies of the case are essential in evaluating the gravity of the charges that the SEC has made against Ripple. This is despite the fact that no Ripple or XRP enthusiast will ever be able to know the conclusion of the litigation. The SEC is calling for the imposition of actual damages on retail investors, despite Ripple's inability to provide proof to support this claim during the motion's substantial dissection process. Furthermore, the SEC is demanding the award of actual damages to retail investors. This has unquestionably already had a number of repercussions for the market, particularly for individual investors and the rest of the ecosystem. The sale of discounted XRP to institutional purchasers is garnering special attention. This has undoubtedly already experienced a number of implications. There is little doubt that these repercussions will occur in the future, but there are also concerns about Ripple's XRP sales once the lawsuit concludes. The San Francisco-based company's revenue generation methods and the types of contracts it enters into with institutional buyers have raised several issues. Given the ongoing legal struggle, Fred Rispoli's study offers valuable insights into potential impacts on the Surge and the cryptocurrency market. In his most recent opinions on X, Rispoli's perspective offered some commentary that shed light on the complexities of the scenario as well as the outcomes that could occur. Despite the fact that this pundit has a tendency to exaggerate his statements over the company's institutional sales practices, Bill Morgan has brought up the prospect that Ripple may be subject to legal concerns as a consequence of the continuing legal struggle with the United States Securities and Exchange Commission. We should consider this in light of the Ripple project's impact on costs and other related issues. The Securities and Exchange Commission (SEC) released a summary of Bill Morgan's graphic concerning remedies 2 days ago. Today marked the public release of the formal discovery. Based on the historical interview, we have learned that the SEC on top of all other sums in response to the damages and fines imposed following the release of this statement. Through his Twitter account, Bill Morgan expressed his worries regarding the claims made by the SEC regarding Ripple's institutional activity. Morgan brought up the Securities and Exchange Commission's SEC accusation that Ripple harmed other institutional investors by offering substantial discounts. As a result of this loss, the Securities and Exchange Commission (SEC) reports that institutions have incurred damages totaling $480 million. Furthermore, the market price of XRP is declining due to discounted sales to specific institutional investors. I need to allocate time in the future to scrutinize all the assertions made in the SEC brief, along with the supporting data. We need more specific details. Morgan asserts that this statement raises the possibility of a class action lawsuit from any and all other investors who did not receive the discounts on their investments. If this scenario plays out, a number of different organizations might file themed lawsuits against Ripple, arguing that the company's refusal to reveal discounts during the process of purchasing anything caused them to suffer some kind of loss. There must be a convincing case for the timing of the discounts, according to Morgan, in order to show causality and file the themed cases. Morgan argues that this is necessary in order to file the themed cases. The Securities and Exchange Commission's designation of Ripple sales to institutions as investment contracts implies the need to declare discounts in the event of registered sales. This particular feature puts a focus on the importance of transparency in Bitcoin transactions while also adding an additional layer of complexity to the procedures that are taking place in court.